Hi there. My name is Stacey Douglas. I'm Associate Professor of Law and Legal Studies at Carleton University in Canada. I want to begin today by thanking Anna Shamisa and Ilan and Christine at Warwick for putting together this series. It's a great idea, I think, to be in touch in these very strange times, especially in light of the cancellation of things like the Critical Legal Conference and other workshops and events that we all plan to see each other at and to share ideas. So thanks again for starting this series. So today I'm going to talk a little bit about a paper, or I'm going to read from a paper that I've written. It's titled. It's titled. Where's my title? It's titled "Jurisfiction and Other Settler Colonial Legal Imaginaries." It's a little bit of a departure from a larger book project that I've been working on that some of you would have encountered in various papers I've been giving for what feels like many years now, around the idea of law or stories of law and law's violence. And in particular, that larger book project focuses on the narrative trope of waking up one day into a world turned upside down. And so those of you familiar or who've heard me talk a little bit about this project will know that Kafka's The Trial is a place where we see this concept in action, but it actually permeates many popular works of fiction, both novels and films, but it actually also makes its way into everyday claims for justice by activists and organizers who are mobilizing to get people off who've been, quote unquote, wrongly convicted or charged with basically national security charges, etc. And so, during the pandemic and with this COVID-19, it seems an apt time to actually be reflecting on that work. But to be honest, I just want to keep working on that. I'm not quite ready to share some new stuff on that. Many of you have seen sort of elements of that work. And so I'm going to just kind of keep working on that book and that idea. And I hope that I will have a manuscript soon. But for today, I'm going to focus on this other piece, which is not entirely disconnected because it is still concerned with the stories that we tell ourselves about law and law's violence. But this particular paper is in the context of Canada and in a particular legal context, which I'll get into, a case that came out last year. So it is a little bit Canadian-centered, but for those of you who are not in Canada, you'll see it has resonances far beyond Canada as it intersects with post-colonial literature and theories of law's violence. And it also is in some ways a tribute, perhaps, maybe a tribute is the right word, to the late Peter Fitzpatrick, who has just recently passed away and who many of us are mourning. So I'll just go ahead and read from the paper and invite people to engage with it in any way they see fit, or if folks have questions about the larger project, or not even the larger project, but the other project of waking up one day on the wrong side of the law, I'm happy to chat a little bit about that as well. So let me begin. In 2012, Conservative Prime Minister Stephen Harper introduced and passed Bills C-38 and Bill C-45, two omnibus bills that made significant changes to environmental protections, as well as the Crown's existing duty to consult with Indigenous communities. This is remembered as the catalyst for the Idle No More movement, which saw thousands of Indigenous people and their allies take to the streets to draw attention to the contemporary colonial landscape of Canadian law and politics. In response, the Mikisew Cree First Nation in northeastern Alberta brought an application against the Crown, arguing that the federal government had a duty to consult before introducing this legislation. Since 2014, the Mikisew have been embroiled in a legal campaign that has at once supported and disavowed their claims. The following paper charts the decisions from these three courts to reveal the fickle and fictive accounts of settler colonial sovereignty that they contain. The most recent ruling from the Supreme Court holds that the Mikisew were not entitled to the duty to consult because ministers, when developing policy, act as parliamentarians, not as the Crown. Below, I explore this reasoning to show that the court's insistence on the precise location of the Crown is performative at best. An analysis of the majority decision, as well as the dissenting opinion from Justices Abella and Martin, demonstrates that there is much more uncertainty at issue than the court concedes. On legal grounds alone, the tension between Canada's traditions of parliamentary and constitutional sovereignty, combined with a commitment to truth and reconciliation, makes this case far from closed. Moreover, the presumed clarity with which the Supreme Court speaks of the absolute distinction between Parliament and executive is part and parcel of a long-standing narrative of an imagined truth of colonial sovereignty. The story goes something like this. Positive law is rational and absolute, and a simple objective analysis of existing law will reveal the correct legal decision. Nowhere in this conceptualization is any iteration of the silences, assumptions, or aporias that make up the mythology of modern law. Moreover, as Peter Fitzpatrick reminds us, this mythical, rational, and well-reasoned Occidental law is always imagined as the better to its Oriental, customary, and savage other. In this way, supposedly objective Western legal reasoning is always contingent on an imagined specter. Revealing this imbrication with its supposedly savage other illustrates Western law's failed project of absolute sovereignty. And yet its autobiography, spelled out in case law like Mikisew, continues to paint itself as the sole harbinger of objective truth, rationality, and authority. My aim here is to render legible the falsity of this assertion, and to suggest that non-Western law should not be dismissed as irrational or unconcerned with process. It is to make room for other laws, both within the confines of the existing settler colonial legal framework, but also, and crucially, outside of it. Ultimately, I argue that the Mikisew's claim for pre-legislative consultation can easily be granted, and that it should, even if such a victory does not represent the horizon of possibility for decolonization. There is another paper to be written on the fact that the federal court's 2015 decision misspells Mikisew as Miseku. The argument of this fictive article may be that it is illustrative of the enormous contempt that the settler legal system has for Indigenous communities, or for the great disparity of language and worldviews between the two. Or perhaps it is an argument about the gravity of seemingly small mistakes, even when committed by a data processor. In either case, I think the error speaks to the importance of confronting settlers' socio-legal imaginaries and their seemingly, at least to settlers, subtle violence. In my visual presentation, which I actually decided I can't include in this paper because my technical capacity will not allow me to, but in the paper that I've written, I allow the misspelled name in all citations from the federal court decision to stay so as to let that mistake resound. So the background. In 2014, the federal court in Canada found that the Mikisew's claim was valid. The changes to the Fisheries Act, the Species at Risk Act, the Navigable Waters Protection Act, and the Canadian Environmental Assessment Act provided, quote, a sufficient potential risk to the fishing and trapping rights so as to trigger the duty to consult, end quote. Importantly, the Supreme Court of Canada found in Haida Nation versus BC, 2004, that actual harm need not be done in order to trigger the duty to consult, but that the potential existence of harm was sufficient. And in 2014, Justice Hughes of the federal court found this to be the case for the Mikisew. Justice Hughes concluded mildly that, quote, notice should have been given to the Miseku in respect of those provisions that unreasonably might have been expected to possibly impact their usual vocations, together with an opportunity to make submissions, end quote. And that the relief given to the Mikisew should be declaratory. Justice Hughes noted that the court must respect the separation of powers, and also that anything more than a declaration at this point, i.e. an injunction, would present too many logistical and legal problems in respecting jurisdiction between the courts and Parliament. So this is the first case that sets this whole series of decisions off. 2 years later in Canada versus Mikisew Cree First Nation 2016, the Federal Court of Appeal found that Justice Hughes improperly conducted a judicial review of legislative action contrary to the Federal Courts Act of 1985, and that by subjecting legislation to judicial review, he failed to respect the doctrine of separation of powers and the principle of parliamentary privilege. While the Mikisew argued that ministers, when proposing legislation, acted as members of the executive, the Federal Court of Appeal found that ministers, when making legislation, acted as parliamentarians, and so were not subject to judicial review. Further, Justice Yves Montagnier, writing for the court, claimed that Justice Hughes was not respectful enough of the boundary between the courts and Parliament. For Montagnier and the FCA, the Federal Court of Appeal that is, imposing a legal duty to consult during the legislative stage, quote, would not only be impractical and cumbersome and potentially grind the legislative process to a halt, but it would fetter ministers and other members of Parliament in their lawmaking capacity, end quote. Yet, in the very next paragraph, Montagnier also claims that, quote, it is good politics to engage stakeholders such as Aboriginal groups on legislative initiatives which may affect them or regarding which they have a keen interest before introducing legislation into Parliament, end quote. For the Federal Court of Appeal, then, consultation on legislation may be good politics, but it is not good law. In Mikisew Cree First Nation versus Canada in 2018, the Supreme Court sided with the Federal Court of Appeal against Justice Hughes and declared that the courts did not have jurisdiction of judicial review because, quote, while cabinet ministers are members of the executive, they participate in this process not in an executive capacity, but in a legislative capacity, end quote. In essence, parliamentary privilege and the separation of powers prevents courts from interfering in the legislative process. Clearly, then, one of the most salient themes to emerge from the Supreme Court case is the issue of jurisdiction. This next section is titled On Traveling Crowns, or Where is the King? The Federal Court of Appeal and the Supreme Court of Canada rely on the Federal Courts Act 1985 to say that Justice Hughes erred in his determination that parliamentarians drafting legislation could be subject to the duty to consult. The higher courts claim that, although the lawmakers in question are ministers, and as such part of the cabinet, which is part of the executive or crown, the body subject to the duty to consult, that at the time of drafting they function as parliamentarians, which keeps their actions immune from judicial review. Justice Hughes thoughtfully addressed these issues in his initial 2014 decision from the federal court. He claimed that in accordance with the Federal Courts Act, quote, the Mikisew are not seeking judicial review of the content of the omnibus bills, nor a decision taken by a member of Parliament, nor a minister implementing legislation, end quote. Rather, quote, the applicant is seeking to engage the process that ministers of the Crown undertake before legislation has been drafted and presented to Parliament, end quote. He goes on to do a careful reading of the legislative process as outlined in a guide published by the Canadian Privy Council Office in 2001, which was submitted by the Mikisew First Nation, as well as oral arguments and cross-examination to conclude that there is ample space to accommodate the duty to consult within the existing legislative process before a bill goes before Parliament. Justice Hughes also notes the inherent tension between Canada's commitment to a clear separation of powers on the one hand and a constitutional duty to consult in the name of the honor of the Crown, given force with Section 35 of the Constitution Act 1982 on the other. At issue here is the slippery nature of the separation of powers when attempting to address Crown conduct that has the potential to adversely affect an Aboriginal claim or right. And indeed, recent case law has allowed for judicial interventions in the name of the duty to consult, even during planning stages. And for this, you could see Haida Nation versus the BC in 2004 and the Mikisew Cree First Nation versus Canada in 2005. Moreover, while lawmakers know that the legislative process is rife with interjections, consultations, and even reviewed by an unelected second chamber, it has also more recently been subject to court intervention. In the British Columbia Teachers Federation versus BC 2016, the government was found to have failed to consult in good faith prior to the introduction of legislation. I return to the issue of meaningful consultation and its constitutional requirement below, but let me note that in this case, the BC Court of Appeal Justice Donald complicates the relation between branches when he asserts that pre-legislative consultation is done by the executive, not by the legislature. Moreover, he cites Justice Major in Wells versus Newfoundland, 1999, as he asks for a reality check when it comes to the myth of the absolute separation of powers in Canada. In Wells, as in the BC Teachers Federation 2016 case, the Supreme Court refused to see the separation of powers as rigid and absolute, and yet a clear distinction was drawn in Mikisew. The next section is called Parliamentary versus Constitutional Supremacy, or Choose Your Favorite Constitutional Principle. Even on strictly legal terms, Mikisew tells a confusing story of settler sovereignty. On the one hand, there is a strong claim amongst the Supreme Court majority that judges cannot interfere in the legislative process if parliamentary sovereignty is to be upheld. In this situation, parliamentary sovereignty reigns supreme, much like it does in UK law, subjugating all other legal considerations. On the other hand, there is also a narrative of constitutional supremacy adrift in this case, amplified at times by dissenting judges. These insights draw attention to the principle of the honour of the Crown, given weight via Section 35 of Canada's Constitution. This unresolved tension between parliamentary and constitutional supremacy, a long-standing dilemma of Canadian constitutional law, gives insight into the conflicting claims of settler sovereignty. Inherent in the concept of the honour of the Crown is the acknowledgement that there is an Indigenous claim to sovereignty that precedes Crown sovereignty. The principle is meant to promote negotiation outside of the courts and is considered to impose a heavy obligation, that's a quote, on the Crown. And that's from Manitoba Métis Federation Incorporated versus Canada from 2013. Even going so far as to be considered a constitutional principle, which is cited in Beckman versus Little Salmon Carmacks First Nation 2010. However, it carries no specific content. While the principle renders legible the tension between competing sovereignties, it is used primarily in the maintenance of settler supremacy and its aim to advance the process of reconciliation. But there is debate about how foundational a role it should play. In their dissent, Abella and Martin cite earlier case law to say that the honour of the Crown should be, quote, the first consideration in determining whether the legislation or action in question can be justified, end quote. This seems to suggest that case law stemming from Sparrow and Haida has already deemed constitutional supremacy to be paramount to parliamentary sovereignty. Abella and Martin further claim that the process of reconciliation demands a practice of ongoing consultation, meaning that the legislative sphere is not excluded from the honour of the Crown, which attaches to all exercises of sovereignty. Amplifying the tension between parliamentary and constitutional sovereignty, they insist that case law has already decided that Section 35 is to be understood as a limit on parliamentary sovereignty. The resounding criticism of the majority decision should not go unheard. More than a difference of opinion, Abella and Martin are pointing to the fickle arguments of the courts. In Sparrow, constitutional supremacy was argued to reign supreme, and in Mikisew is subjugated to parliamentary supremacy. And it is this inherent precarity of legal reasoning that I want to draw attention to. Moreover, the justices pick and choose which unwritten constitutional principle they want to privilege. In this case, democracy is the winner, and nowhere do we hear a consideration of other unwritten principles, such as the protection of minorities in secession or the honour of the Crown in Little Salmon, both arguably relevant to the Mikisew case. Are we to assume then that there is an unspoken hierarchy to these unwritten principles? Or is it that the lionized electorate that the court imagines is always already non-Indigenous? The next section is called The Myth of Modern Law, or Eternal Return of the Same. And for some of you who've been listening and are feeling like a little bit too deep in the weeds of Canadian constitutional law and the duty to consult, this is a little bit of a broader picture to put some of the more intricate stuff in conversation theory. Jurisdiction, although commonly attributed to a geographical or territorial demarcation, lays at the heart of the maintenance of legal authority. Etymologically descending from the root words juris and dictio, jurisdiction translates from the Latin into speaking the law, and as Austin Surratt claims, quote, manifests law as performative through speech. It signifies not just a spatial demarcation of law's reach, but also a staging of authority to make pronouncements that present themselves as being law, end quote. In this way, jurisdiction is what brings law into being. Jurisdiction makes law, and along with it, sovereignty. Thus, jurisdiction invents law, much like the signature invents the people in Jacques Derrida's work on constitutional authority. But as Surratt points out, this enactment is performed. It stages authority. Thinking about jurisdiction as an utterance renders bare the very tenuousness of law. This is why Jean-Luc Nancy refers to it as jurisfiction. Quote, the persona of the judge and his edictum are forged from the same fictitious gesture, unquote. This is not to say that such jurisfictions do not have real-world consequences. Sherry Pasternak's work with the Algonquin Nation at Barrier Lake in Canada, and of course the ongoing dispute on Wet'suwet'en territory and elsewhere, shows that the state's power to subjugate comes precisely from a complex network of jurisdictions, all oriented to maintaining settler colonial control of Indigenous land and resources and, quote, erasing Indigenous law, end quote. That's from Pasternak, 2017. And yet, dwelling on the concept of jurisdiction and its essence as an utterance, a staging of authority, quote, makes visible a governing and productive instability in the law, end quote, from Braden Cormack, 2009. It is this instability that we must exacerbate at every opportunity, and what I hope to have done in small part in this reading of Mikisew. To conclude, my point about the ultimate indeterminacy of the Crown's precise location, or the tension between parliamentary and constitutional supremacy, should not be mistaken as a relativistic argument. In this case, and more generally in approaching legal issues of decolonization, there's a strong discourse that asserts that pre-legislative consultation with Indigenous communities is too complicated. I want to be clear that it is not. Abella and Martin, echoing Justice Hughes from the federal court, offer several simple legal answers. They note that the federal government's duty to consult during the lawmaking process is a component of the Crown's overarching obligation to deal honorably with Indigenous peoples when regulating their rights, and as such, is not confined to a particular time or place. Rather, quote, the honor of the Crown is always at stake in dealings with Indigenous peoples, end quote. Moreover, such an obligation has a precedent in the BC Teachers Federation versus British Columbia in 2016, and the court's duty to ensure this obligation is upheld has been set out in Sparrow, Haida Nation, Taku River, and Mikisew Cree. Finally, it is also worth noting that a mere victory for the right to consultation in the pre-legislative stages does not mean, one, that Indigenous communities did not retain the right to continue to challenge the same legislation after it has been passed, nor that, two, Canada has fulfilled and exhausted its requirements owed to those communities. Canadian law's narrated existence as a well-ordered, rational, and therefore supreme law is built on an imagined other, supposedly backwards and customary law. What I've tried to show here is how that narrative of superiority is created despite settler colonial law's own logical leaps. While much Indigenous resistance and refusal happens at a distance to and in spite of the settler colonial state, more work needs to also be done by Canada's settler colonial public, including practitioners and socio-legal scholars, to challenge the imaginations of law that animate our current landscapes, and how we might make room for alternative stories of justice and legal systems, both within and without the contemporary settler colonial state. So thank you very much, and I look forward to your questions, which I will answer. Well, I will try to answer. Thanks again to WARC for organizing this. Take care.